Carol Beaumont.
Thank you very much, Mr Chair. Mr Chair, I want to focus in quite closely to Clause 4, you'll be pleased to know, and actually look at what this clause is about and basically what it says. Now, this is supposedly about clarification, and that's what the previous speaker talked about, and this is, of course, the substantive part of this bill, the Employment Relations Film Production Work Amendment Bill. Now, the first question is there a need to clarify? And while it was very interesting for the Honourable Dr Nick Smith to go through the history on the matter, the reality is that as of 2005, with the Supreme Court decision in Bryson, we have settled law in this matter. There have not been a raft of other cases on the matter. There have not been a whole lot of people flip-flopping between status as independent contractor or employee, which might have been something that people were concerned about. That might have been an issue of uncertainty, but it would appear that that has not been the case. And my colleague Charles Chevelle went through quite carefully yesterday the provisions of that case, and of course he should know he was in fact one of the lawyers involved in the case. But certainly the matter went through, looked at a very clear set of tests to determine the real nature of the relationship. But look, what's happened here is we've put up a provision in response to a dispute and a threat that the Hobbit would not be made in New Zealand. But the actual issue of dispute was not the question of whether somebody was an independent contractor or an employee, or uncertainty around that matter. What the Honourable Dr Nick Smith seems to have so much difficulty with is that workers might try and improve their situation, and in that case it was a group of independent contractors, actors and technicians who wanted to try and improve industry standards. As independent contractors, they were not seeking to negotiate a collective employment agreement as employees. They were seeking to collectively negotiate around industry standards, something they are perfectly entitled to do, something that has previously been done with the Pink Book, and frankly, there was an agreement reached that that was exactly what would happen. When this dispute was resolved, some time ago now, and in fact all of the parties were notified, and of course the party that failed to recognise there was a resolution, the party that failed to recognise that any questions around banning anything had been lifted, the party that actually was deceptive in all of this was Warner Brothers, and it suited the government for that to be the case so they could keep the hype up on all of this. The reality was the actual issue was resolved. This is a different issue. Now, why is it that this Act is looking at the meaning of the word employee? Clause 4 raises the issue of the meaning of employee, and it talks about it in relation to film production, goes on to say that it talks about who's covered, so it's a person in film production work as an actor, voiceover actor, stand-in, body double, stunt performer, extra singer, musician, dancer or entertainer, or a person engaged in film production work in any other capacity. So that covers the rest of the people in film production, and it goes on later to talk about pre-production, production work and post-production. So this potentially includes everybody, the cleaner, the person answering the phones, all of the range of people involved in film production work, including the production of film or video games. So, yeah, hairdressers, all sorts of people. So the reality is that it talks about those people, and what it does is it creates effectively a default situation. It says that those people are independent contractors unless. And then this is, of course, the area the Minister's got into a little bit of trouble with around that wording about when they might be an employee. And my colleague Charles Chevelle went through that yesterday and explained that, in fact, potentially this bill could create even more uncertainty. So from a situation of settled law to, in fact, a situation of more uncertainty, and the Minister has responded, all credit to her, by putting forward an amendment to try and pick up the point that Charles Chevelle made, because she recognised it was a legitimate point. Now that takes me to my next issue around putting up a clause like this and a bill like this, which is getting it right. If the government's serious and believes there is uncertainty, then getting it right is important. The worst possible outcome would be to put up a bill that actually creates less certainty, and that's what I'm worried about here.
The Honourable Tau Henare.
Thank you, Mr
Just
Chair.
before the member speaks, I meant to just draw the House's attention to a matter that occurred while Nick Smith was speaking, and I didn't want to interrupt him. But standing orders and speakers' rulings are quite clear on visual aids, and during a member of the government speaking, visual aids were displayed from the other side. They are to be displayed only when members are speaking on that side, and we won't have a repeat of that. Honourable Tau Henare.
Thank you, Mr Speaker, for that assistance.